Hi, today I'm going to do a brief introduction to contracts. And it's going to be brief because the purpose of this is not to cover in detail everything in contracts, but rather to introduce you to those things that are going to be covered on the bar exam, MBE and essays, and to encourage you to read Barbry's long outline at least 2 or 3 times between now and the bar, because that's where you'll get the details. I'm not going to fill in all those details as part of this lecture. How do you approach contracts? Well, as I've said with all of the subjects, I think you need a big picture to fit the little pieces in, and I think you need to spend maybe an hour studying the table of contents and thinking about the big structures and where things fit before you plunge into actually reading the outline in more detail. Now, you can look at the law of contracts in terms of mnemonic devices. I prefer to think of it as a story that you can go home and tell to a non-lawyer in your family to have them make sense out of what it is that we study in and cover under the label contracts. And I'll confess at the beginning, when I went to law school, contracts to me was the single most mysterious subject in all of first year. And it remained so at the end of first year, and it didn't really begin to make sense to me until I was already a law professor and decided to take the bar examination, decided to study for the bar, and I got to contracts and said, I never really liked it or understood this stuff. And now I think I understand the structure of contracts pretty darn well, and I really enjoy it a lot more. Contracts is just how society deals with promises that we make of a general kind, determining whether to enforce those promises, whether to require us to either do what we promised or to provide some kind of remedy if we fail to do what we promised. Now, there are areas that are carved out like family law and so forth, but basically, how do we deal with promises? And a contract can be defined as a promise or a series of promises for the breach of which the law gives a remedy. Okay? Or a promise or a series of promises that the law will enforce. Okay? That's what a promise is. Now, before you go any further, you need to be aware, as I assume most of you already are, that we have 2 sources of law that we apply in contracts. This, your family that you're explaining it to don't really need to know this, but you do. We have the common law of contracts that's evolved through England over hundreds and hundreds of years, and we have the Uniform Commercial Code, UCC. You need to think, as soon as you see a contracts problem, is this covered by the UCC or by the common law? And you need to think about that because the UCC differs from the common law on a fair number of issues, and those issues are particularly likely to be tested on the bar examination and particularly likely to help designers of multiple choice questions in making tempting wrong answers. They give you a fact pattern that is covered by the common law, but they give you a very tempting UCC answer. Or they give you a fact pattern that's covered by the UCC and then give you a tempting common law answer. So you need to be aware, are we under the UCC or are we not under the UCC? And you should think about that at the very beginning of analyzing any contracts problem. UCC covers Article 2, contracts for the sale of goods, period. Sale of goods. You do not need to have merchants involved for the UCC to apply. The contract need not be for $500 or in excess of $500 for the UCC to apply. Those are special parts of the UCC. The $500 is for the statute of frauds to come into play. The merchant concept is one that brings certain UCC rules into play. That is, if we have a sale of goods, there are some special UCC rules that apply only to or differently with merchants than with non-merchants. But in general, the UCC covers all sale of goods, no matter how much the cost, and no matter whether the buyer and seller are or are not merchants. All sale of goods. Common law covers everything else. Okay? Now, if we're going to have a promise for the breach of which the court will give a remedy, where do we start? Well, we have to start with knowing whether we have a contract. Contract formation is a substantial part of what is tested on the bar examination. How do we form a contract? That is, what behaviors, what acts of people lead us to have the kind of promise that the courts will enforce. And that's a promise involving mutual assent plus consideration. Mutual assent, often thought of in terms of an offer that gets accepted, and there needs to be consideration. We'll come back to this in more detail. We need that plus the consideration, and if so, we have a contract. However, we need to think, are there any defenses? Are there promises that would seem to be enforceable because the parties agreed and there was consideration given for the agreement, but the parties came to this agreement based on a mistake? Mistake can get you out of the contract. It's a defense to there being a contract in the first place. Or certain kinds of contracts, certain kinds of agreements are required under a thing called the statute of frauds to be in writing, and certain things must be in the writing, and who must sign the writing. Statute of frauds is a defense to enforcement of a contract. So even if we meet the requirements for formation of a contract, it may still be unenforceable defense called statute of frauds. So if we formed a contract, we have a set of promises for the breach of which the courts would give a remedy, and we don't have any of the typical defenses. We'll come back more. Now we have a contract. The next step in thinking, I believe, best is, in our fact pattern, are there any people who get any rights who are not part of that bargaining process? Anybody other than the offeror and offeree who anywhere in our fact situation get any rights? Third parties. And we have labels for those third parties. Some of them are called third-party beneficiaries. Some of them are called assignees. And some of them are called delegates. And we'll come back to why that is. But are there any third parties who get any rights or duties under the contract? Now, we have a contract, enforceable contract, and we know who might have any claims under this contract, the parties and the non-party claimants. But we still don't know what this contract means necessarily. What if we have a writing, but there were some discussions that took place before the writing was signed, or at the very moment that the writing was signed, or some other agreements that were put in writing before the final agreement was signed? If there's a dispute about what the contract means, are we allowed to look at these discussions to help us understand the meaning of the words in the contract? Parole evidence rule. Big testable subject. 2 or 3 questions every time on the MBE on whether we can bring in prior or contemporaneous evidence of discussions to help us understand the contract or to change the meaning of the contract. Parole evidence rule is part of interpreting the meaning of the contract. The other part is just what are the meaning of words, and something as simple as we use the ordinary reasonable person. Meaning of words, not extraordinary or special meanings. A little bit of that is going to appear on the test, but mostly parole evidence rule in terms of interpreting the words of the contract. Now, if you were not a law student, you might think, well, that's it. Now we have a contract, now people have to perform. But now we really come to what is the big central issue of contracts: conditions. Are there any conditions, especially conditions precedent, things that must happen before a party has to perform? We have this generally in contracts. Suppose there's simply a deal between A and B for A to sell and B to buy A's car for $500. Who's got to perform and when? The contract, the agreement didn't say. If the contract is silent, we imply an order of performance, implied conditions as to the order of performance. And conditions being so important, you must understand this. When it's an exchange of a thing for money, both of which can be exchanged at one moment, each is a condition precedent to the other. That is to say, the person selling the car must tender the car before the money is due. The person buying the car must tender the money before the car is due. If neither one of them tenders performance, the other party does not yet have to perform. Time to perform has not yet arrived. That's different in terms of order of performance from a contract where one person is doing work over time and the other is paying for it. Typical example comes up all the time. A is painting a house for B. A's completion of the painting of the house is a condition to B's duty to pay, a condition precedent to B's duty to pay. In other words, if the contract doesn't say who's to go first, the person with a duty to do a performance over time must complete that performance before the money is due. The painting of the house is a condition precedent to the duty of the person to pay for that. Okay? So we have conditions precedent and we have conditions concurrent when they both can occur at once. Forget conditions subsequent, they don't much matter. But in addition to conditions as to order of performance, there are many other conditions that can exist in the contract, both express conditions and implied conditions. Express conditions exist in contracts on a fairly regular basis. I will buy your car if the Phillies win the World Series this year. The Phillies winning the World Series this year is a condition precedent to my duty to buy your car. If it doesn't happen, if that condition does not occur, then it would seem I don't have to buy the car. That's a kind of silly condition, but any condition expressed in the contract can be an express condition of the party's duty to perform. So now let's back up to a definition of a condition precedent, and this is one of those very abstract things like the definition of hearsay or the definition of relevance and evidence. You can listen to it, say, oh yeah, that makes sense, but it's very abstract, and if you don't understand what it really literally means, how it applies in facts, you'll get confused. It'll be worthless. A condition precedent is an event that must either occur, happen, or else be excused before the other party has a duty to perform. Condition precedent is an event that must either occur or be excused before the other party has to perform. So the Phillies winning the World Series is an express condition precedent to my duty to buy your car. Either the Phillies win the World Series, in which case now my duty has matured, or the Phillies lose the World Series, in which case that condition is never going to happen. How would we excuse a condition? Big area of testing on the exam. Major area of testing on the exam. Every time, multitudinous questions. And there are all these terms that you see, and if you don't understand that they function as excuses for conditions and what that means, you're going to be confused. And even when you first look at this, you're liable to be confused for a while. So you look in the Barbary Outline under things that excuse conditions, and there's a list, 7 or 8 of them. I've never memorized it, I see no need to, I have no mnemonic device. I just look at it. But I know one of the things that excuses the occurrence of a condition is if a party frustrates the occurrence of that condition or fails to act in good faith to help that condition occur. For example, the Phillies are about to win the World Series, and because I don't want to buy your car, I kidnap their star pitcher to prevent them from winning the World Series. If I have gone out of my way to prevent the occurrence of a condition, that condition is excused, it's no longer on the table, and my duty to perform matures. People have to cooperate and not frustrate the occurrence of a condition. That's actually tested fairly regularly. But more importantly, substantial performance. Suppose the party doing the painting has done the painting but slightly imperfectly. If it hasn't been done properly, then has the condition of proper completion occurred? No. But if it's been done almost properly, substantially properly, whatever that means, then the condition of complete performance is excused and the other party has to pay with a set-off for damages on account of the minor breach. Substantial performance excuses complete performance. Anticipatory repudiation, prospective inability. Both of those concepts appeared on the test in 1972, the Granddaddy test. They appeared in 1978, they appeared in 1991, they appeared in 1998. They love them, they always appear. Anticipatory repudiation and prospective inability, and they are often issues on essays. What's the difference between them? We'll come back to that. So there are a number of things that are conditions, or that excuse the occurrence of conditions in contract, and you want to pay very careful attention to them. But as you proceed through the outline, the next thing you'll find are things that discharge the contract. Because if the conditions have either occurred or been excused, now it's time to perform. Has the contract been discharged by complete performance or something else that discharges the contract so that we'll be done with our analysis? We won't have to go on. How do you discharge a contract? Impossibility discharges a contract. A has a contract to paint B's house. Before A can get there with the paint, B's house is burnt to the ground in a fire. There is no longer a house to paint. It is objectively impossible to paint a non-existing house. Therefore, the contract is discharged. Nobody has any duties under that contract. But that's only one. There's a list of about 15 or 20 things that discharge a contract, including accord and satisfaction and many other things. So you want to study the list of things that have the effect of discharging contract. Now, suppose we don't fall within the discharge. We've done an attempt at performance, but it has failed in some way. Breach can be major or minor, material or minor breach. And there are a page or two on this in Barbry's outline. It's not very long, but you want to pay attention to this, because if the breach is minor, the other party still has to perform but get a set-off for damages. If the breach is material, the other party does not have to perform. So you need to be aware of whether a breach is material or minor, and the tested area in this on a regular basis is whether time is of the essence. We'll come back to that. Finally, remedies. If we had a contract that was not properly performed, so that there's been some kind of a breach, time to perform arrived and there's been some kind of a breach, what are the remedies? There's always the possibility of specific performance in those rare cases where we give specific performance, but be aware that specific performance is not given of personal services contracts. We need no adequate remedy at law, and we need it not to be a personal service. Most of the time our remedy is going to be damages. General rule of damages is going to be expectation damages. We want to put the non-breaching party in the position that he or she would have been in if the contract had been properly performed. Put the non-breaching party in the position that they would have been in if there had been proper performance. But we have to figure out what that would have been, and it varies depending on the kind of contract, construction contracts, employment contracts, and so forth. So you'll find several pages of Barbry filled with specific rules as to how we apply expectation remedy in various situations. But in addition to expectation, a person can also get what we call consequential damages. The extra that they were going to get out of the contract, for example, lost profits that they might have gotten had the contract been properly performed. Example, one of the most famous cases in all of the law of contracts, Hadley against Baxendale. You don't need the case name, but the concept is always on the test, where a delivery company took a shaft from a mill to be repaired and failed to return it on time, so that the mill was shut down for some number of days because they're waiting for their shaft. Can the mill collect lost profits for the period of time they were shut because the contract had not been performed? Rough, simple answer: not unless it's either a consequence which would follow in the ordinary course of events, so everybody would expect that kind of consequence, or if it's not ordinary, if the injured party had disclosed this risk at the time of contracting. I go to UPS, I give them a package, I pay them $50 extra to deliver it to California tomorrow. They don't deliver it to California tomorrow. They've breached the contract. Do they owe me for the $2 million that I lost because I would have gotten $2 million worth of profit had the particular item been in California in time to be used? Well, ordinarily, most packages are not going to, being a day or two late is not going to cause millions of dollars of lost profits. So in the ordinary course of events, that wouldn't occur. And if I told UPS, hey, if you get there a day late, it's going to cost me $2 million, UPS would say, fine, we sell insurance. Here's what you have to pay to buy insurance, right? Hadley against Baxendale. You only get consequential damages, lost profits, if they would ordinarily follow, so it was quite predictable at the time of the contract, or if they were disclosed at the time of the contract. And there are a number of other remedies. And now we're done. We've gone one time through the law of contracts, but let's go back and hit some things in a little bit more detail, and then your job is going to be to study the table of contents yourself for about an hour, and then read the outline. So when you study the table of contents, you look and you see, oh, there's about a page on what is a contract and whether things are covered by the common law or by the UCC, a page or two in the outline. We get to pages 2 to 32. Barbary talks about formation issues. Mutual assent plus consideration, I would put them all together in terms of, have we formed a contract? Have we formed the kind of agreement that could lead to a remedy if it gets breached? Mutual assent plus consideration or some substitute for consideration, and no defenses. 3 things we have to think about. Assent, consideration or a substitute, defenses. On assent, one might summarize it in a simple sentence. You have mutual assent when an offer gets accepted before it gets terminated. Because when an offer is made, it gives another person, an offeree, the power to form a contract. As long as the offer is open, the other person, by saying yes, can form a contract. However, once the offer gets terminated, it's too late for the offeree to form the contract. So we need an offer that gets accepted before it gets terminated. Now be careful about what's an offer. An offer is not the same thing as a hint that you're willing to receive bids on something. An offer's got to be definite, communicated to a person or persons who can accept offerees. Restatement defines an offer as a manifestation of willingness to enter into a bargain that is so communicated as to justify another person in thinking that his assent is invited and will conclude the deal. Not necessarily a direct quote, that's as I remember it. An offer is a manifestation by the offeror. It can't be just in his mind, it has to be manifested. Manifestation by offeror of a willingness to enter into a bargain. I'm here, I'm ready to sell my car. Communicated to someone else, either a definite offeree or in some cases to a group of potential offerees, communicated in such a way as to justify the recipient in thinking that his or her assent is invited. Please agree to buy my car. And the minute you do so, a contract will be formed. So the offer leaves nothing but yes to the formation of the contract. That's an offer. It has to be definite, communicated, and allow the other person to conclude that his assent is going to be enough to conclude the deal. And acceptance has to be a manifestation of agreement to the offer. And here's one key point that's tested all the time. Common law, quote, mirror image rule, says that an acceptance must be identical to the offer, no difference in terms. You can't say, Rich, I'll sell you my car for $2,000, put it in writing. And I respond by saying, fine, if you put on new tires. That's not an common law, might be UCC. Let's make it a house. Rich, I'll sell you my house for $500,000. Well, given deflation, I'll sell you my house for $100,000. And I say, fine, I put it in writing, but only if you put in new windows. Any additional or different term in an acceptance or a purported acceptance at common law means it's not the mirror image, which means it's a rejection counter offer, mirror image rule, tested all the time, as opposed to the UCC 2207, which allows for differences between the offer and acceptance sometimes to still form the offer. This will be tested, so you want to study the battle of the forms in your outline. Okay? Offer has to get accepted before it gets terminated. Now, what can terminate an offer? All sorts of things. But in general, offers are revocable. That's the easiest way to terminate an offer, is if the offeror revokes the offer. Are offers always revocable? No. They're generally revocable, and again, something that's tested regularly, all the time. An offer is revocable, but there are a few instances where it is not revocable. Number one, if we are under the UCC, then if the offer is made by a merchant, here's a special merchant rule. If a merchant makes an offer under the UCC in writing, promising to hold the offer open, then in fact that offer will not be revocable for the time stated in the offer or for a reasonable period of time, if time is not stated, but never to exceed 3 months. Complex little rule, wonderful testing, right? Merchant firm offer. Secondly, if an offer is made but consideration is given for holding the offer open. I'll pay you $100 to hold that offer open. Good, I'll take your $100. It's called an option contract. If consideration is given for holding an offer open, we call that an option contract. Therefore, it's irrevocable as long as the option's available. Third, if an offer is made in circumstances that the offeror should have realized the offeree might rely on the offer, and the offeree actually does rely on the offer, then the offer has to stay open for a reasonable period of time. This occurs mainly in, you'll see it in contractor-subcontractor cases. Subcontractor puts in a bid that a general contractor uses on a bigger bid, and while the general contractor is waiting to find out whether his general contract bid has been accepted, he's not in a position yet to accept the subcontract offer. He's just used the subcontractor's offer in figuring out how much to offer on the general contract. Then the subcontractor says, oh, I changed my mind. If the offer of the subcontractor was one that he or she should have realized the general contractor was going to rely on, general contractor did rely, then it becomes irrevocable for a reasonable period of time, okay? Or a funny little thing called a unilateral contract, not nearly as much tested as people fear, but it appears. A unilateral contract is a contract where the offer can only be accepted by a performance and not by a promise. Walk across the Brooklyn Bridge on your hands, I'll pay you $500. The only way to accept this is not by saying I agree, but by actually doing the performance. Turn in Osama bin Laden and we'll give you $50 million. Awards, rewards like that. Unilateral contract offers can only be accepted by doing the act, not by promising to do the act. Well, what if a person begins to do the performance? That would be the acceptance of the unilateral contract. If they actually begin the performance, then the offer is not revocable for a reasonable period of time to allow the completion of that performance. These rules about when offers are not revocable tested quite regularly. So if offers that can be revoked, but if they haven't been revoked or otherwise terminated, they can be accepted. That's the mutual assent. Consideration, the main thing that's going to be tested is what is known as the pre-existing duty rule. And you'll find that in your outline. And you'll find under the pre-existing duty rule exceptions. Just like we found in evidence that hearsay exceptions are a major tested subject because the rule against hearsay is worth a question or two, but the exceptions are worth 8 or 9. Well, consideration is mostly tested in terms of the exceptions to the pre-existing duty rule. If I have a duty to do something, and then I say, give me more money for doing that which I already have a duty to do, unenforceable. To modify a contract, another way to put the very same thing, to modify a contract, there needs to be consideration for the modification. I'm saying, I have a duty, we've agreed I will paint your house for $5,000. I say, you know, I know we have a contract $5,000 to paint your house, I want $6,000. And you say, okay. Since we already contract for $5,000 and you're giving me an extra $1,000, that's what I'm getting. What am I giving you in return? Nothing except what I already had a duty to do, pre-existing duty to do it. unenforceable. That kind of modification is unenforceable under the pre-existing duty rule. Exceptions, loads of them. If there's a dispute about the duty, for example, if the duty is in dispute, then the settlement of the dispute can be the consideration. I say, yes, I know we had a contract for me to paint your house for $5,000, but we're having a dispute as to whether the painting was to be done in a certain way. We're having this dispute, and I say, okay, well, I'll do it, but you have to pay me extra. We had a dispute. The settlement of the dispute would be the consideration, even though I'm not doing anything that I might not have originally been obliged to do. Study the exceptions. You will be tested on the exceptions, at least 1 or 2 questions every exam. Absolutely. You will also be tested on a way around the doctrine of consideration, which is known as reliance or promissory estoppel. When a promise is given that the party should realize the other party might rely on, and the other party actually does rely to his detriment, then even if there was not consideration given for the promise, the reliance may make that promise enforceable to the extent necessary to avoid injustice. You want to study those rules. Tested generally 1 question every test. Defenses to contracts are tested a number of questions every test. Mistake. Every area of the law, pretty much every area of the law, mistakes are important. In criminal law, mistakes are important, right? If the criminal defendant says, I made a mistake, if it was a reasonable mistake, it's a good defense to some crimes. If it was an unreasonable but good faith mistake, it's a good defense but only to specific intent crimes. Mistakes are important. In tort law, mistakes are important. If I believed that you were attacking me, I have a right of self-defense as long as my belief is a reasonable belief, so I'm allowed to make a reasonable mistake. Well, likewise, in contract law, mistakes are very important, and you'll see a number of different doctrines of mistake right in the table of contents. There are mutual mistakes, there are unilateral mistakes, there are mistakes by intermediaries, Western Union, UPS, communication companies. There are secretarial errors, so-called, or clerical errors. If there's simply a mistake in the typing's a fairly old-fashioned word, in the word processing, in the creation of the document, and nobody notices it, that's a kind of mistake. If the 2 people are using the same word, but they mean different things by that word, famous case involving the ship Peerless, but one party meant one ship called Peerless, another party meant another ship called Peerless, and so their minds never met. They were thinking they were contracting about the ship Peerless, but there were 2 different ships. That's a kind of mistake. Mistakes generally allow people to get out of contracts in certain circumstances. They're a way to get out of a contract that seemed to have been enforceable. Mutual mistake, important, is an awful lot like impossibility that we'll deal with later. With a mutual mistake, the mistake has to be about what the circumstances were at the time of contracting, as opposed to impossibility, which refers to events that occurred after the contract was already formed. Example, we make a contract about excavating under the ground. We did not know at the time of contracting that there was something under the ground that was going to make the excavation more expensive. We deal with that in terms of the doctrine of mutual mistake. We were mistaken about what was under the ground. Impossibility, it has to refer to events that occur afterwards, not events that as they existed at the time of contracting. So, we have a contract for me to paint your house for $5,000. No mistake, the house is there. But after the time of contracting and before the time of performance, the house burns down. It has now become impossible due to an event that occurred afterwards. Mistake refers to events that existed prior to the time of contracting. Impossibility refers to events that occur afterwards, but they both are fundamentally the same. That is to say, they let a party get out of the contract at the earlier part with mistake, unless the party who wants to get out of the contract expressly or impliedly assumed the risk of that problem. You'll see that language in Barbary. Barbary did not create that. That's in the Restatement Second of Contracts. unless the party who wants to get out of the contract expressly or impliedly assumed the risk of that event. If I'm an expert and the other party is not an expert, the courts may say, well, yes, you were both mistaken, but you had the kind of expertise that impliedly put that risk on you. That's the issue that comes up all the time. With impossibility, the same language is used by Barbary and the same language is used by the restatement. If the impossibility occurs, but one of the parties had specialized knowledge so that they should have realized that it might happen, then they may be held to have impliedly assumed the risk of that event. So, impossibility and mistake are both limited by the requirement that the person who wants to avoid the contract not have expressly or impliedly assumed that risk. That's mutual mistake. But there's also a thing called a unilateral mistake. Picture, unilateral, one person made a mistake. If one of our two contracting parties made a mistake and the other didn't, then can the one who made a mistake get out of the contract? Yes, if the other person knew or should have known of the mistake and was taking advantage of it. So we have mutual mistake, unilateral mistake, Western Union miscommunicates kind of mistake, my secretary makes a mistake in the word processing kind of mistake, the ship's peerless kind of mistake, a number of different kinds of mistake. There are other defenses that are tested, but not often, unconscionability and so forth. The other big area of testing with defenses is the statute of frauds. Certain kinds of contracts must be in writing to be enforced. Generally must be signed by the party being charged with a breach of contract and must contain whatever are the essential terms for that particular type of contract. So with the UCC, the type of contract, the essential term is quantity. What's the quantity? And signature by the party being charged. With land sale, the essential terms include the names of the grantor and grantee and a description that allows us to locate the land. With employment, the essential terms include the length of the contract. How long? 6 months, a year, whatever. Those things must be in writing if the particular contract must be in writing. You want to study what kinds of contracts must be in writing, what must be in the writing, and then you need to study the things that get you out of the statute of frauds, the exceptions to the statute of frauds. I'm not going to go through this is all in the outline, but study that. So if the statute applies, you discuss that first or think about that first, then you think, are there any exceptions that might apply here? Statute of frauds. As I said, there are some other areas of defense, but we're not going to talk about them. Leave that to your reading. Non-parties, Barbary's pages 32 to 42, pardon me. 3 big concepts always tested on the MBE, always tested. Third-party beneficiaries, assignments, delegations. And then there's a thing called novations, not much tested, generally down as a wrong answer. Third-party beneficiaries, who are they? They are persons who are named or provided for, even if not by name, in the original contract itself. That's how you know it's a third-party beneficiary rather than an assignment or a delegation. In the original contract, I contract to paint your house for $5,000, and I say, and pay the first $2,000 of it to my daughter, Rachel. Rachel being named in the original contract as a third-party beneficiary. Or you're an insurance company and I want life insurance. I come to you and I say, I want to buy $500,000 worth of life insurance covering my life, payable to whomever I designate. Third-party beneficiary can be someone who's designated at some time in the future, as long as the contract specifically provides for a performance for that third-party beneficiary. Big issues with third-party beneficiaries. Is the beneficiary an intended beneficiary or only incidental? If they're only incidental, people who would incidentally benefit, but it was not done with the intent of benefiting them, they do not get enforceable rights. Only intended beneficiaries get enforceable rights. Second big area of testing, vesting. The original parties to the contract, the people who bargained with each other, can change their minds and extinguish the rights or lessen the rights or modify the rights of third-party beneficiaries until the moment of vesting. So when the third party beneficiary vests, the original parties can no longer change their minds. And there are three things that cause vesting. Either the third party beneficiary sues, relies in a reasonable and expected way, or manifests assent to being a third party beneficiary. You need to recognize when people vest and when they don't. And another point to make with third party beneficiaries, just because there is a contract that provides for the payment or performance to a third-party beneficiary doesn't mean third-party beneficiary automatically, and even though the third-party beneficiary is vested, doesn't mean third-party beneficiary is going to collect. Because the third-party beneficiary doesn't collect until the money or the performance is due. And if the original parties, one of them breaches so that the performance is not due, then the third-party beneficiary still will not collect. Okay, study all that. Assignees and delegates. Assignees get rights, delegates get duties. After the time of the original contracting, if one of the parties transfers his or her rights or his or her duties to a third person at some time after the original contract, we no longer are talking third-party beneficiaries, we're talking assignees if we're talking a transfer of rights as to get paid, or we're talking delegation if we're talking a duty to do a performance. If we're talking about both, I have a contract to paint your house for $5,000 and I transfer all of my rights under that contract to Jones, another painter. All of my rights and duties under that contract, I transfer the whole contract. That's an assignment of the right to get paid and of the duty to do the painting. It's also called an assignment of the contract. Assignment of the contract includes assignment of rights and delegation of duties. That phrase, I assign the contract. You need to study carefully the various language, the language used with assignees and delegates, and when those things are revocable and when they're not, and when an assignment is proper, almost always, when a delegation is proper, when a person must accept delegation, only if the service is not one of special trust or professional or artistic services, is the duty delegable or not always tested. So definitely spend some time thinking about that, since most of us didn't study that at all in law school. Now, we've got a contract, we've dealt with defenses, we're back to construing the contract, general rules, reasonable person, meaning of the language, and the parole evidence rule. I'm not going to spend a lot of time on the parole evidence rule. It's 3 pages or so in the Barbary outline, page 44 to 46 or thereabouts of Barbary's outline, right? But first, do not confuse parole evidence rule and statute of frauds. There's a tendency to confuse them. They have nothing to do with each other. But the people who draft multiple choice questions know that we tend to confuse them, we students and takers of bar examinations. So they will give you a fact pattern that raises a parole evidence question and give you a statute of frauds answer that will be wrong because irrelevant. Or they'll give you a statute of frauds question, give you a parole evidence rule answer that will be irrelevant. You have to know the difference. Why do people confuse them? Because they both have something to do with written and oral stuff. But they have very different things to do with written and oral stuff. Statute of frauds says certain kinds of contracts must be in writing or can't be enforced, and tell us what has to be in the writing to make it enforceable. Some kinds of contracts must be in writing, certain things must then be in the writing, otherwise it's not enforceable. Parole evidence rule is not about defenses to enforcing the contract, but about the meaning of the contract. What can we use when it comes to interpreting the contract? Therefore, we have a writing. Parole evidence rule doesn't apply at all unless we have a writing. If we have a writing, when can we bring in prior written and oral discussions that might help us interpret the writing, or that might be inconsistent with the writing, or that might add to the writing? When are we allowed to bring in the evidence of this other stuff? That's what the parole evidence rule is about. So you need to be aware of the limitations on the parole evidence rule. That's the big thing with the parole evidence rule. To what kinds of things does it apply in the first place? And then what are the exceptions to that parole evidence rule? Tested all the time, 2 or 3 questions on every bar. UCC has a different parole evidence rule than the common law, tested fairly often, right? So be aware of the difference between, study that when you look at Bro-Evans rule. Back to conditions, a second run through on conditions, right? I told you the first time through. A condition precedent is an event other than the mere passage of time that must occur or be excused before a party has a duty to perform, before the duty to perform matures. And we can have express conditions, we can have implied conditions, and we can have constructive conditions. And you want to read that page or two of the Barbary outline with great care. You want to recognize conditions. Major reason you want to recognize conditions is because they have to either occur or be excused before the other party has to perform. Now you go down the list of excuses. And I'm sure somebody has a mnemonic device for it, and I don't know it, and I have not memorized the list, and I just hate mnemonic devices personally. But I recognize those things that excuse conditions because I've studied that list, I've thought about it, and I recognize them in facts. Failure to cooperate excuses the occurrence of a condition. Someone could have helped that condition occur, but they tried to prevent it from occurring. That excuses it. Anticipatory repudiation or prospective inability excuse the condition. What's the difference between them? They sound a little bit alike. So people tend to confuse them. So they tend to put them together in the same MBE question. Anticipatory repudiation involves a situation where one of the parties says, I will not do it. They have to be clear. I will not do a future performance. They have now repudiated. Prospective inability is simply something that puts the other party in doubt as to performance. I may not be able to perform. My employees may go on strike. I'm worried about going broke. You read in the paper that the other company is having trouble paying their bills. Any kind of information that comes that suggests the other party to the contract may not be able to perform may raise a question of prospective inability. See, it's inability to perform rather than repudiation. And the consequences of those two doctrines is very different. With anticipatory repudiation, the non-repudiating party can cease his present performance and sue immediately for breach, for example. With prospective inability, can't do that, can only cease present performance and demand further assurances, different remedies. Substantial performance excuses complete performance, so that the other party has to pay with a set-off for minor damages. Divisibility. If the contract provides for equal performances for equal amounts of compensation, I will build you 5 houses for $200,000 each, and I build the first 3 and then I stop. I have not substantially performed the whole contract, so since I haven't substantially performed, can I collect nothing? If the promises are truly divisible, I can collect the $200,000 each for the first 3 houses, minus whatever damages I would owe for the failure to do the rest of the contract, divisibility. And then a really big one that's been on every release test at least once and often several times, waiver. A person who has the benefit of a condition can always say, I don't care. I waive it, or do something that would indicate the person doesn't care. Any condition in a contract where a party has a benefit of the condition, the party can, by his behavior or by his words, say, I don't care whether that condition occurs, and thereby waive the condition, therefore the performance becomes due, even though the condition didn't occur. Conditions must occur or be excused before the other party has to perform. Discharge. We've gotten to the point where the duty to perform has arrived. Has the contract been discharged? By performance. The person actually did what they had to do. Or tendered performance. Or it became impossible. There's a list of about 20 or 25 things that discharge a contract. I see no need to memorize them, but I would go through the list and be aware of the effect of those doctrines. Accord and satisfaction, for example, appears in the list of things that discharge a contract. Impossibility discharges a contract, and you need to know that. If we have an impossibility or we have an accord and dissatisfaction, the effect is to discharge the contract. One little test result of this is that if they give you a fact pattern that looks like an accord and satisfaction, and you say, gee, I'm hunting for an answer that says accord and satisfaction, it's not there, it's because they put down as the right answer, contract is discharged. Because that's the effect the accord has. Or, hey, gee, it's impossible, they don't give you that answer. The contract has been discharged, becomes the correct answer because that's the effect of the impossibility. And accord and satisfaction, as an example, is not one word, it's accord and satisfaction. It's two separate things that come together. There is an accord, which is an agreement to settle a dispute, and there's the performance of the accord, which is called the satisfaction. Well, what if the parties enter into an accord? They've settled their dispute about the contract in a contract of accord, but then party doesn't perform the accord, it doesn't satisfy. The non-breaching party can sue either on the accord or on the original contract, because the original contract does not get discharged until the accord has been satisfied. Okay? So you want to study the methods of discharge of contract. Next, material versus minor breach. A couple of pages in the Barbary outline talk about the factors that the courts use in determining whether a breach is material or minor. Study those carefully. But the most important item in that couple of pages is this: timely performance. If a contract says, I will paint your house and will be finished by July the 5th, and it's July 6th and I'm not done, is that a material breach so that you can treat it as a total breach of contract, go hire a substitute, and so forth? Generally, failure to perform on time is a minor breach, not a material breach, unless time is made expressly of the essence, and time is of the essence under this contract, or unless the circumstances are such as to make it clear that time was of the essence. Failure to perform on time only allows for damages for the delay. Contract for the sale of land, closing was to be on June the 15th. It's June 20th, closing hasn't yet occurred, but the seller finally cleared up the title and says, here, I'm ready. It's June 20th, 5 days late. Can the buyer say, whoops, you're 5 days late, no deal, I don't have to buy it? No. Unless time was expressly of the essence, or the circumstances make it clear that the people understood time was of the essence, then the short-term delay simply allows the buyer to get damages for that short-term delay, whatever they might be. Generally, measure of damages in that circumstance would be rental value for whatever that period of time would be. So you need to think, is the breach material or minor, particularly with timely performance? Finally, remedies, as I discussed earlier. Damages, expectation, study the special rules for expectation damages. Study the Hadley against Baxendale consequential damage rule. Be aware of the limitations on specific performance. We do not give specific performance of personal services contracts. And be aware that we also have other possible remedies: restitution, rescission, quasi-contract. I'm done, but for one thing. Go through the whole of this study again, thinking UCC versus common law. As you look through the table of contents, note every time that the table of contents mentions, here's a special rule for sale of goods, here's a special rule involving merchants under the UCC, because those things are particularly heavily tested all the way through the test, through the exam. As I said, it's easy to make multiple choice questions in which the fact pattern is a common law fact pattern, but there's a tempting UCC wrong answer. Simple example. I mentioned earlier, firm offer rule is only a rule that makes an offer irrevocable under the UCC, firm offer by a merchant. But what if we have a land sale contract and they go out of their way in the fact pattern, as they will, to say that the seller deals in houses and land and has hundreds of them to sell, and then makes this offer very firm and clear and says, I'll hold this open. And then they give you a firm offer rule answer. It's wrong. Firm offer rule simply does not apply a common law. It's a UCC rule. So you need to focus as you go through the table of contents on where they tell you there's a different rule between common law and sale of goods. Hunt for those. Output and requirements contracts, firm offer rule, implied warranty of merchantability when it comes to things of that sort, battle of the forms versus the mirror image rule, and so forth. Perfect tender rule, all over the outline. Perfect tender rule is a good example because we have this doctrine I mentioned earlier, substantial performance. Now you all remember now where that was, right? It's an excuse for the occurrence of a condition. I didn't complete the contract totally and perfectly, but I almost did. Substantial performance, therefore you have to pay me minus damages for the minor breach. That's the common law rule. But the UCC has a special rule called the perfect tender rule. It only applies when we're under the UCC and only applies when we have a one-time deal, single delivery of goods under the UCC. The offer, the tender must be perfect. No substantial performance won't do. I have a contract to buy 100 bushels of wheat that you are to deliver to me on December 15th. By the way, I happen to be using those to make special pastry goodies for Christmas, right? You show up with 99 bushels. Do I have to take the 99 bushels and subtract damages for the missing bushel under the UCC? I can take them if I want to, but I don't have to. Under the perfect tender rule, I can say, go home, I don't want your 99 bushels. It's not a perfect tender. You have the right to cure until the time for delivery, but not beyond. So be aware that's one example of, or another example of a difference between the common law and the UCC. As you go through the common law contracts outline of Barbary, notice those differences. Barbary also has then an additional 20 or so page outline on sale of goods that will add rules that are just particularly special to the sale of goods. Enjoy your study of contracts. As I said, when I went to law school and studied contracts, I found it a mystery. When I was already a law professor, but was studying for the bar exam, I said, gosh, this stuff is a mystery. If you study the structure and then the details of Barbary's table of contents of their contracts and sales outlines, I think you'll see that it flows and it makes sense. Thank you.